All right. Hello again, everybody. Of course, it would not be a presentation in 2025 if we weren't talking a little bit about AI. So that is what Nicole and I are here to do today. So I'm going to take a general sort of broad overview of what we're seeing as far as AI in the HR space. And then Nicole is going to dive in on one of the particular issues that we're tracking right now. So I'm sure everyone has had pretty broad exposure to the concept of AI, but just to make sure that we're all talking in the same language, I mean, AI and the concept and term AI has been around since the 1950s. So it's not new. It's just generally referring to computer technology that can simulate human intelligence in different ways. But what we're really seeing, the generation and the expansion and explosive growth, is in what's called generative AI. That is what we're going to be focused on today. So I asked generative AI to define itself. So if you need a definition of generative AI, it's generally referring to a subset of AI that really can produce more sophisticated tasks or perform more sophisticated tasks, whether it's analyzing resumes that are coming in, assessing pay data, helping you take input from employees about performance or questions, responding and helping you develop content and policies. It really is a sort of exploding area where the AI is producing unique things for us as opposed to just assisting us in tools. So there are, certainly a number of opportunities that AI offers us in the employment law space, where we're seeing it used. Processing large volumes of information and data, particularly those of us who are a single person or a small group HR team. You don't have time to go through. Previously, you were facing the challenge of going through, 150, 200 resumes that are coming in, looking at all sorts of performance metrics that are coming in before review time. And it does allow you to streamline and use some of these tools to help you navigate those large information documents and data. It also helps create uniformity. I mean, you've heard our colleagues talk about the issues that you have with manager discretion, how certain managers can really create a problem for your organization by doing something wrong or handling something differently from the norm. It can really help you track those things. I actually just had a call with one client the other day who was using AI to go through and audit all their compensation structure to look at, hey, who hasn't gotten a raise in X a period of time and who's gotten raises disproportionate with their standard rate, because each manager and each supervisor was having the discretion to give raises. And they noticed some things that were anomalies. They had some people who, were going out every year getting that offer from a competitor. So the supervisor was saying, oh, I really want you to stay. I'm going to push you up another rung. I'm going to push you up another rung. And other people who'd been there for 10 years and had gotten a 5% bump between year 1 and year 10. So, things like that were previously something that would have taken them a really long time to look at and assess that pay data. They were a fairly large company with over 50 people. They were able to run this fairly quickly. Reviewing and improving work product. Reviewing and improving work product. Obviously, we are all using, the editing tools, but also if you are in depending on the industries, we're seeing it a lot being used to make sure that there is some level of quality control that's not necessarily human quality control, similar to creating efficiencies. And then also increasing responsiveness. We've seen employers who are using AI surveys, chatbots, to help with routine questions of, where can I find the policy on XYZ, instead of having to go to HR with each question to find each document that's clearly found in an employee handbook or in a plan document. Having a system that allows employees to use AI to get those answers quickly and without having to use a lot of human resources to do that. And I encourage you all to share with each other, whether now or later, but, I'm hearing new ones every day. So, having a dialogue with each other about the other ways that you're using using AI to benefit your HR practices, because it is a ever growing and evolving field. But of course, with opportunities come shortcomings. And what we're seeing in the shortcomings are creating some legal risks for our clients. The first is with inaccurate and incomplete information. We've heard a lot and talked a lot about the idea of these hallucinations. So AI producing information that is inaccurate. what we're running into and seeing more is not hallucinations, but more commonly information that is only partially correct. And I'll give you an example of that in just a moment. But information that is legally accurate, but is missing that really key step. There's also the issue of lack of transparency in the process, and I'll get into that when we talk about some of the hiring tools and the way AI is being used in hiring. But AI is largely a black box. We know what comes out of it, but we as the users often don't know what's going on behind the scenes and how that is being developed, and that poses risks for us. That ties into the concept that I will discuss shortly about the potential for discrimination and bias, because we do not know as the user how our AI was trained, what biases might be inherent to the AI training, or exactly what it's looking at to make these decisions and recommendations that it is feeding out to us. Similarly, intellectual property violations, we've seen issues with that as well, where the content that's being created, perhaps your employee is using it to do some work for a client, doesn't realize that when they've asked AI to produce something, that AI is literally lifting something verbatim from something that is another source on the web, and you're now plagiarizing. And then it's also eliminating training opportunities in human learning. That's something I've been talking with a number of my clients about, is that the things that you used to train entry-level people or new employees on, it's now being done by AI. We're seeing that in the legal field. We're seeing that across different spectrums, because there are these easy tasks that people say, well, it can be quickly done by AI and better. Why should I let that new person who just started do this, and then I'm gonna have to edit their work? It's gonna take time. I can just have AI do that. But it's making it harder and harder for us to train those new staff members if we have managers, supervisors, and more senior people just relying on AI to do things that used to be done by a human. So I took this opportunity to, when we're talking about inaccurate and incomplete information, to see if AI could replace you or us when it comes to HR and employment law competencies. And I'm pleased to report that we cannot yet be replaced. So interesting just test cases. I posed a question to 2 different AI platforms, one being ChatGPT, the most commonly used one, to say that I'm an employer in Montgomery County, 22 employees. Our employees worked for us for 6 months. She just had a baby. She doesn't have any PTO. How much time do I have to give her, and does it have to be without pay? So when I posed that exact question, both of them came back and basically said, well, it's up to your policy. What I was trying to catch is whether they would realize that I'm in Montgomery County and there's mandatory sick and safe leave in Montgomery County for people starting on day 1, and Montgomery County extends mandatory sick and safe leave to parental leave. With the way I phrased it that way, neither of the AI platforms caught that or identified that sick and safe leave might be an issue for me. When I rephrased it and said, we don't give PTO, not that she does not have any PTO, one of the platforms did catch and said, wait, you need to be giving sick and safe leave. The other gave me the same output. She hasn't been there long enough. You're not FMLA size. She's not there long enough for Maryland parental leave. So it's totally up to you. So, it gave me a great rundown of what FMLA is and the eligibility for FMLA, gave me a great rundown of Maryland Parental Leave Act and what the eligibility requirements would be there. But it missed that really key core concept, which was obviously a concern. And since I was intentionally trying to walk it into this trap and see if it knew, I knew the hole was there. But if I did not know the hole was there, it was great information and looked really accurate. Similarly, I asked both AI platforms to write me a policy for a Maryland employer for vacation. Here, I was looking to see whether the AI knew about the Maryland Flexible Leave Act, which requires a disclaimer at the end of the policy saying you can use the vacation for the death or illness of an immediate family member under the same terms and conditions as you can use it for any other purpose. Again, neither of them drafted the policy with that necessary disclaimer language or identified that to be an issue for me. So for the HR professionals out there, you can be reassured that there is still a lot that AI has to learn, but particularly with more junior people in your department who may be looking to AI because they've not had the training or experience that you and I have had throughout the years of learning just on the ground as being an HR professional or being in employment law. It can be really easy to miss that issue spotting when you're just relying exclusively on AI. So taking a look a little bit at sort of where we're seeing AI come into the employment life cycle and where we're seeing these risks and challenges, really the biggest one we're seeing sort of explode both on the use front and the litigation front is with recruitment and hiring. So that's using AI to screen candidates, chatbots to respond to questions, and then AI-driven tests or even AI interviews. There have been some significant cases evolving here. Again, this goes to the idea of the black box of AI, not exactly understanding or knowing how AI is coming up with and doing the things that it's doing. There's one case that just got filed conveniently for me about a month ago in the Eastern District of Michigan. Interestingly, it's a very well-written pro se case, so it's an individual representing himself. He sued SiriusXM. He's in the IT field. He applied for 150 different positions at SiriusXM and was rejected from every single one of them, even though he was qualified. And his allegation in there is that, first of all, there is a direct disparate treatment in that whoever designed the AI intentionally created discriminatory traps within it. But what I think is going to be ultimately his more successful argument is that there's a disparate impact, that there's biases built into the AI system that are causing him to be screened out at these early stages, because the way that SiriusXM system works is it goes through and uses AI to screen and score resumes. And he alleges in the complaint that the AI is using race-based proxies to screen out based on what successful applicants previously looked like or what successful employees previously looked like. So successful employees in this job, they look at educational institutions. You know, if you've had people who've always gone to Harvard, maybe it's just looking and bumping up people who have Harvard on their resume. It also is including the zip code of people who were applying, which obviously in certain jurisdictions can be highly tied to someone's race or ethnicity. So that is an interesting case that we're going to be watching, but it really shows the idea that, you know, they may not have necessarily built this as a tool that was going to, hopefully did not build this as a tool that was going to be screening people out, but are potentially going to have challenges because they were using it and they weren't paying attention to realize that certain of these items were bumping people's scores down. Also, items we're monitoring, the ACLU has 2 different EEOC charges pending. One of them deals with whether employers can be liable for bias built into vendor tools. And passing that on to not just if you had your own in-house tool and not just the vendor who's building that AI tool, but to the employer who elected to use it. And the other deals with accessibility in AI. This was an individual who was deaf, who did an interview with an AI bot. The initial interview that this company was using was with an AI system. And her allegation was that the captioning, the AI captioning, was not adequately sufficient for her to be able to engage in a proper interview with this AI bot. And so she got rejected because she could not have an effective conversation with this AI because she was deaf and having issues with the captioning. Another sort of major one that we've been tracking for a while, and it was covered in our presentation last year, is still chugging along in the Northern District of California, is Mobley versus Workday. That just got certified in May as a nationwide ADA collective action. So a large case. And here it's the algorithm that Workday, which is a HR platform, was using, was essentially, allegedly, screening out people who are over 40 and also engaging in disability and race bias based on the way that it was screening people. EEOC recently filed an amicus brief in this, and to the question in those ACLU cases I was referencing, at least to this point, the court has held that Workday was acting as an agent of these employers that were using it for the purposes of allowing these claims to go forward against Workday for the biased outcomes that were occurring in the hiring process. So that's just recruitment and hiring. Also with onboarding and training, we're seeing people using a lot as far as tracking what needs to be done, training modules, fielding questions from employees. One thing to flag here is, again, going back to that ADA concept that Julie was talking about, Onboarding is often when you have that first touch with employees and when someone may bring up the fact that, hey, I might need an accommodation to do my job, or might realize that they might need an accommodation to do their job. And if they're interacting exclusively or primarily with AI functions, A, it may be difficult for you to identify that, and B, you may have an issue with them attempting to communicate it or believing that you should know or have realized that this was something that was occurring, but there is not actually, you're not actually getting the message in there, or they're not conveying the message appropriately to you because what they're doing is talking to an AI chat bot who's fielding their questions. Engagement and performance management. Feedback, I've seen clients using this to assess performance data. If people have analytics, if you're in sales and you have to hit certain numbers, it can be a lot faster to look through, have AI do an assessment and compare employees. And then we're also seeing this used a lot in remote employee management. So I would also flag, sorry, in the remote employee management in particular, the DOL issued a field assistance bulletin back in 2024. So whether the DOL still stands by that assistance bulletin remains to be seen. But it said that employers are not relieved of their FLSA violations just because they're using AI to track employee time. So I would flag that, particularly with remote employee management. We're seeing a lot of folks starting to use AI to, when someone logs in, when someone logs out, when someone, times as dormant, using AI to do that instead of having employees manually enter. I started my day on this time, I took a break this time, I took a break this time, but being really careful that you understand how those AI systems, if you're using those AI systems to do any type of time tracking, be really careful, because we're, according to the DOL, at least the latest position, you can be held responsible for that. So what are some sort of intelligent ways to be careful and to think strategically about using AI? Obviously thinking about how it can help you, don't avoid AI because it's here to stay, and there are positive uses. Thinking about current uses of AI by employees and vendors. I can't emphasize vendors enough, because as we've seen, a lot of these situations involve, it's a vendor product that employers are adopting, and then the employers are the ones being held liable for that. Look at your indemnification clauses in your vendor contracts. Are the vendors saying, we take no responsibility if an employee sues you because the AI that we're giving you comes up with, a disparate impact? Or is the vendor taking responsibility financially if you get sued or if there's an issue? And even if you're not using sort of a vendor who is just exclusively an AI vendor, how is your payroll company using AI? How are some of these other vendors you're working with using AI in a way that could negatively impact you? Developing, updating, and enforcing your use of AI policies. So dealing with how your employees are using AI. And I say updating, for those of you who heard me speak before, I'm the person who is on the phone with a lot of you in November saying, have you updated your handbook yet? Because things are constantly changing, and especially AI. If you set your AI policy back in 2023, I can almost guarantee you that it's probably out of date, because you probably aren't anticipating some of the ways that your employees are using AI. And enforce it. If you know that employees are using ChatGPT, you've told them not to use ChatGPT because you don't want your information on a public function, enforce it if they're doing it. Because if you're knowingly letting them use it and letting these violations go through, then the policy is really not worth much. Offering training so employees know what the policies mean and how to comply with them. And don't allow AI to replace human knowledge and judgment. That comes back to the idea of, talking about accommodations, looking at who we're actually hiring and who's getting screened out. Looking at whether we really have pay disparities or discipline issues. Just because AI says that someone doesn't need leave when they're pregnant doesn't mean that you shouldn't go back and double check a little bit for yourself, and be careful that when you Google, the answer you're getting up there is also AI. So making sure you're actually doing your due diligence. And then understanding the AI you're using. What are the strengths and weaknesses of it? What are you putting in, and if the information you're putting in, is that a closed system AI, or are you putting information in that is going to, become the learning model for that AI, that you're putting confidential employee information into a non-closed system. And then staying up to date on trends and laws, simply because, I went through 5 new cases just since we had this presentation last year, and this is really significantly changing. So before I hand it off to Nicole, just touching a little bit on what an AI policy should include, because sort of policies are my favorite part of working in employment law. So thinking about what tools are approved and how they can be used. So not just, you can use AI or you can't use AI. What kind of AI can we use? Can we use the open systems? Can we use the closed systems? And which specific tools and how can we use them? Can we input any information or should it really only be publicly accessible information? The latter is really what you want. How do we address data privacy and confidentiality concerns? I'm sure most of you have heard about the fact that someone at Samsung ended up putting information into ChatGPT in the early stages, and now if the Samsung code for some of their products is in ChatGPT because these AI learning models are learning from the information you're putting in. So making sure employees understand, particularly if you have confidential information, if you're working in the HR space about employees, or you have that sensitive confidential information that Jason and Lori were talking about your company, reasonable steps to maintain confidentiality of your trade secrets does not include putting your trade secrets in ChatGPT because you want ChatGPT to summarize them or, assess them. And again, reviewing work product, emphasizing to your employees that anything that they're getting from AI absolutely has to be reviewed. We've all probably heard about the embarrassing cases where judges have been getting pleadings from attorneys that have cases that are completely non-existent. So making sure that you stand by, any employee has to stand by their work product and actually have verified it, confirming that they're not having any IP violations if they are using any AI, if they're permitted to, and then again, just ensuring that there's a statement in there that employees really need to be maintaining legal compliance in all aspects of their job, but also in using AI. So watch is pretty self-explanatory. It's evolving, there are changing norms, and the laws and regulations are changing every day. So I will turn it over now to Nicole to further emphasize some of the issues here with AI.
Okay, good afternoon, everyone. As Jessie mentioned, we gotta get the PowerPoint up and running. Okay. All right, now we're good. Good afternoon, everyone. As Jessie mentioned, my name is Nicole Behrman, and this afternoon I'm going to be discussing artificial intelligence and its impact on employee classifications. As Jessie alluded to, artificial intelligence is prevalent in our day-to-day life, including in the workplace. In many cases, AI has changed and reshaped employer practices and also employee duties. This has helped streamline processes and allow both employers and employees to become more efficient. It may have also had unintended consequences and impacts, specifically on employees' exempt statuses. AI can be used to automate certain job tasks, and also, in some cases, it can be used for tasks that previously required human discretion and independent judgment. And if exempt employees or employees that are classified as exempt are using AI in this fashion, they may no longer qualify as exempt and may need to be paid minimum wage and overtime. Now, to back up a little bit, as we all know, under the Federal Fair Labor Standards Act and similar state law, employees generally need to be paid the applicable minimum wage for all hours worked and overtime at a rate of 1.5 times the regular rate of pay for all hours worked over 40 in a work week. Some states go beyond the FLSA and have different overtime triggers, For example, working over 8 hours in a day. Regardless, General rule, employees need to be paid minimum wage and overtime unless they qualify for an exemption. Generally speaking, to qualify for an exemption to the minimum wage and overtime requirements under federal law, the employee must meet the duties test of the applicable exemption and generally must be paid on a salary basis of at least $684 a week. Nothing new there. For purposes of our conversation today, we're going to go through a brief overview of some of the most common white-collar exemptions, the executive exemption, the administrative exemption, and the professional exemption as outlined under the FLSA. Again, some state laws may differ in their criteria. Okay, first, we're going to discuss the executive exemption. To qualify for the executive exemption, the employee's primary duty, that's their major, their most important duty, must be managing the enterprise or managing a customarily recognized subdivision or department in the enterprise. Managing includes activities like interviewing, selecting, and training employees, setting or adjusting employees' rates of pay or their hours that they work, directing their work, maintaining records of employee productivity to supervise them and provide them direction and feedback, rating their performance, handling employee complaints and grievances, and disciplining employees. To qualify for the executive exemption, the employee also must customarily and regularly direct the work for 2 or more full-time employees or their equivalent. So that could be 4 part-time employees that together work 40 hours a week. The employee also has to have authority to hire and fire the employees, or their suggestions and their feedback and recommendations have to be given particular weight. Moving to the administrative exemption. To qualify for the administrative exemption, again, the employee's primary duty, their major, most important duty, must be the performance of office or non-manual work directly related to the management or general business operations of the employer or their customers. So here, an employee must perform work directly related to assisting with the running and servicing of the business, as opposed to making the product that's sold, right? Making the widget. This would include work in areas like tax, finance, accounting, advertising, marketing, safety and health, human resources, public relations, and legal and regulatory compliance. To qualify for the administrative exemption, the employee's primary duty also has to include the exercise of discretion and independent judgment with respect to matters of significance. This means the employee has to evaluate options and then make a decision on how to proceed forward on matters that are significant to the employer and the employer's business. This decision can be subject to review at a higher level. The FLSA has certain factors to consider when determining whether an employee exercises his discretion and independent judgment with respect to matters of significance, like whether the employee has authority to formulate policies, whether they carry out major assignments when conducting the operations of a business, whether they have the authority to commit the employers to matters that have a significant financial impact, whether they have whether they provide, consultation or expert advice to management, whether they investigate and resolve matters of significance, and whether they can represent the company in handling complaints, arbitrations, or resolving grievances. And lastly, we're going to cover the professional exemption. There are 2 types of professional exemptions. 1, the learned professional exemption, and then 2, the creative professional exemption. To qualify for the learned professional exemption, the employee's primary duty must be the performance of work requiring advanced knowledge. This advanced knowledge must be in a field of science or learning, like medicine, theology, law, accounting, and the advanced knowledge must be customarily acquired by a prolonged course of specialized intellectual instruction. And then finally, the creative professional exemption, the employee's primary duty must be the performance of work requiring invention, imagination, originality, or talent in a recognized field of artistic or creative endeavor. So we started the presentation talking about artificial intelligence, and we just went through some common white-collar exemptions under the FLSA. So the question is the intersection of these 2 things. What happens to an employee's exempt classification if they use AI to perform some of these job duties that make them exempt? So if you have a manager that's using AI to screen candidates or select candidates to offer the position to, or if you have an advertising executive that's using AI to draft pitches and develop strategies for their clients, or if you have a musician who would have previously qualified for the creative professional exemption that's using AI to write their songs instead of them writing it. In today's world, this could give rise to a misclassification lawsuit. And I think we're going to start seeing more cases like this with the prevalence of artificial intelligence in our day-to-day life. Now, in most cases, there's human oversight to artificial intelligence, but it's unclear how much human oversight is needed to pass muster under these exemption tests. And of course, damages for misclassification can be significant under the laws. So we have here federal law, Federal Fair Labor Standards Act, Maryland law, DC and Virginia law, and the damages that they impose for unpaid wages. And they're steep, right? You have Maryland law that you can get damages of up to 3 times the amount of unpaid wages. And you have DC law that you can recover up to 4 times the amount of unpaid wages. And then there's attorney's fees and costs associated with that. So these decisions and review of them can have significant financial impact. And there's not a lot of case law currently litigating this issues to provide employers with guidance on how to analyze these issues and whether an employee would still meet an exempt classification with their use of AI. Now, we do have 2 cases here that predate AI as we know it, that might help shed light on how a court would analyze these issues and how we as employers can analyze these issues. The first case is Lola versus Skadden, and this is a Second Circuit case. This case involved a contract attorney that sued the firm that he worked for, claiming that the firm didn't pay him overtime for the work he performed. The plaintiff performed document review work. So he was an attorney, he used software to review documents in a case that the employer was litigating for one of their clients. And he reviewed documents to determine, do we produce these documents to the other side as a part of this litigation? He argued that this work was devoid of legal judgment. He did not have to use any legal judgment to review these documents and determine whether or not to give them over to the other side. The firm filed a motion to dismiss the plaintiff lawsuit, saying, look, this lawyer is exempt from overtime. We don't owe him overtime. He was acting as a lawyer. He qualifies as exempt under the professional exemption, that learned professional exemption that we were talking about earlier. Lower court agreed, dismissed the case. However, the plaintiff appealed and the appellate court reversed. And in doing so, they relied on the plaintiff's allegations that his work was devoid of any legal judgment. Instead, the court said he's alleging that his work consists of looking at documents to see what search terms, if any, appeared in the document. And if they did, he would check it and then he would move on to the next document. He would mark those documents in categories that were determined by the firm. And then he would draw black boxes to redact certain portions of documents based on specific protocols that the firm provided. And the court said a fair reading of this complaint shows that the work the plaintiff did, in the light most favorable to the plaintiff at this stage in the case, could have been done by a machine. So he's made a plausible argument that there's been a violation of the FLSA when the employer did not pay him overtime for the work performed. And the court remanded the case back down to the lower court to continue litigating the issue. They settled. And here we have another case also out of New York here, a lower district court case, Hennig versus Quinn Emanuel, that went a different way. Here, the plaintiff held a similar position. He was a lawyer, he was reviewing documents in a case using software to determine whether or not to produce them in the case that the firm was litigating for their client. He made similar allegations. He said, look, you didn't pay me overtime. I'm not an exempt employee. I don't qualify for the professional exemption, for the learned professional exemption. You should pay me overtime. And the court disagreed with the plaintiff in this case and dismissed the case based off the employer's motion to dismiss. And here, what the court said is while the attorney had search terms provided by the firm he was looking for in the documents, he made the decision whether or not that document needed to be produced. Just because the document had the search term in it did not mean that he would automatically say, yes, we have to produce this, or no, we don't. He also reviewed the document to determine whether or not it was privileged. So the court said, look, based off these allegations, he was retaining that legal discretion, right? He was using his legal knowledge and maintaining discretion when using this tool to perform his job. So, well, these cases just scratch the surface and they don't technically deal with artificial intelligence that is prevalent in today's world that we're juggling with. I think they serve as helpful indicators to what a court is going to look to when analyzing a potential misclassification suit from an employee that was classified as exempt that does not believe that they should because of their use of artificial intelligence. So, best practices for employers. Juggling the new use of artificial intelligence that's prevalent in our day-to-day society. How do we use artificial intelligence and struggle and navigate this intersection with exempt classifications? So first, understand how certain roles are using artificial intelligence. If you're using artificial intelligence as a part of your business, you want to understand how your employees are employing that strategy and that resource. Periodically review roles to evaluate whether the role still meets the exemption criteria with the artificial intelligence. And if the role does not meet the exemption criteria that you had previously classified it under, change the classification and classify that employee as non-exempt. Also, ensure employees are using independent judgment, analysis, and discretion when using artificial intelligence. You want to make sure that they're not just looking at the output and saying, okay, that's it, we're moving forward. Train and provide employees also with opportunities to engage in problem solving independent of their use of AI. And finally, as Jessie was talking about earlier, develop policies for the use of artificial intelligence. And that concludes our artificial intelligence portion of today's presentation. Sure.
I just really want to know if that question was Lola.
Yeah.
So if that person gets to now be non-exempt, do they also get to now not get an attorney salary, like an attorney fee? Because if you now get it to be non-exempt, you don't get an attorney salary.
Well, so the question is, does that person, if you have to classify someone as, reclassify someone from being exempt to non-exempt, you know, how would you determine their pay? And I think it's going to have to depend on a lot of different things, state laws and whatnot, and wage transparency and things of that nature. But you can certainly make, you know, you're going to have to change their compensation structure because they're now going to be paid an hourly rate and they're eligible for overtime. You could still have them paid on a salary basis, but you're going to have to modify that structure to reflect that they now are earning minimum wage and overtime in accordance with the law and making sure they're being treated, you know, the same as others. Sure.
So some AI is capturing time on and off the clock for people that are working remotely. So for the exempt person that you're clocking their time worked, does that make you lose the exemption also? Because now you're looking at their hours worked?
Yeah, that's I mean, if you have people who are borderline, that's actually a best practice that I often recommend. If you've got people who maybe they're exempt, maybe they're not exempt. I mean, Jim and I had a case a couple of years ago where we were literally going through someone's cell phone records to figure out when they left the restaurant in Bethesda to go home to their house in Vienna because they never tracked their time. So if you have people who are borderline, AIs actually can provide a good, efficient, and cost-effective tool to track the time for someone who you are treating as exempt, but to make sure you have time records just in case they ever challenged it.
Tracking their time wouldn't make someone automatically not exempt.